And welcome to Moneylife. This is Sucheta Dalal. This week we are talking about the National Stock Exchange. No, not about its IPO, but about the fact that a division bench of the Delhi High Court has said on the 1st of this month that NSE is a public authority under the Right to Information Act and that the RTI Act should be applicable to it. This is good for all investors. I'm sure a lot of you have a lot of questions. The point is, it's taken 16 years from first moving court to get here. 2010 is when this happened. And that's how long the NSE has fought. In fact, actually, a little longer. Add another year. Is it all going to end now? We don't know because remember, it's a division bench of the Delhi High Court. Logically, the NSE can appeal, go to the Supreme Court, or SEBI can bring everything to a halt. We don't know which way it will go, but it's interesting to hear the background of the story. It started with an investor file asking questions, NSE rejecting it, saying the Right to Information Act is not applicable to it because it's a private company. There is a series of appeals. Then it goes to the Central Information Commission under the RTI Act. The Central Information Commission had a full bench hearing and decided that the Act applies to NSE. NSE immediately challenged it. This was in 2010. It went to the Delhi High Court. Why Delhi High Court? We don't know because NSE is Bombay based, right? Its business, its head office, everything is here. But it went to Delhi. It was heard by a single judge, Justice Sanjeev Khanna. Now, Justice Sanjeev Khanna gave a fairly strong order which upheld what the Central Information Commission had said and said NSE is a public authority and the Act is applicable to it. 2010. Since then, for the next 16 years, this has dragged through a division bench. No hearings happened or hearings happened, tariq pe tariq. It didn't move. Meanwhile, of course, you know that Justice Khanna went on to become the Chief Justice of India and even retired in 2025, but NSE's appeal continued to drag through the division bench. Finally, there's been an order on 1st of July. What has happened in the meanwhile? You buy time, it's always to the advantage of those who do not want something to happen. So, in these 16 years, the RTI Act itself has been defanged and eviscerated so much that the exchange might now say, why bother to appeal and accept the judgment? And then stonewall queries, as everybody else has done. All government departments do it. The regulator also does it. But at least in principle, the Act ought to apply. And the Securities and Exchange Board of India, as a market regulator, can bring this whole story to a halt. But 16 years, SEBI has been silent. It went to the Central Information Commission and argued pretty strongly that yes, NSE is a public authority, it's strictly governed by SEBI, by CRA. But as you know, this got challenged and there was a comprehensive ruling. But in these 16 years after that, SEBI could have issued orders. It did nothing. It watched. It watched to see what happens with the Delhi High Court. Now, there's another judgment. Even today, it is time for the regulator to act. But look at it another way. 16 years is not the only story. Look at what has happened in these 16 years. If anything, it has only strengthened the case for greater public scrutiny of the National Stock Exchange. Remember, it is not just a profit making private company, it is a near monopoly market infrastructure institution which is a first line regulator, a de facto public utility. It handles trillions of rupees worth of transactions every day, and it is supposed to regulate systemically important market participants, which is the brokers. It has to ensure fair trading. So it's got a regulatory role as well, and it's tightly governed by SEBI and the SCRA. Now, NSE has been getting away with it because for over 2 decades it has cultivated the image of an exemplary organization with perfect governance, great board. All that just collapsed in 2015 when I published a whistleblower's report in Moneylife exposing what is now known as the co-location scandal. They first sued us for defamation, 100 crores. We won the case. The matter went on. That letter The whistleblower's letter described how select brokers were getting an unfair advantage and access to backup servers on the exchange. I'm not going to go into details about what is co-location, but essentially it means that large deep pocket traders have their servers on the exchange so that they can access prices faster. Now, we're not going to get into whether this is fair to other traders or not, but this is a system that is in place. But even here, there was discrimination, not only against ordinary investors, but against other colo traders as well, because some were enjoying this special protection or special access, and the exchange was not willing to act on specific complaints. All this is now a matter of long investigation that has gone on, quite a botched up investigation, if you ask me, and I've done video blogs on this. But it exposed serious governance failures, capricious appointments by the NSE, and the fact, scandalously, that its then managing director, Chitra, was making decisions under the guidance of, believe it or not, a Himalayan guru who had an email ID with whom she would share confidential financial projections, board agendas, human resource allocations. Now, the beauty and the irony of the Indian system is that neither the regulator nor other investigation agencies, including the CBI and others, have been able to find who this Himalayan guru is with an email ID. Is it believable? But that's how investigations are in India. Anyway, the passing of this information by none other than MD itself was highly irregular. Appointments were irregular. She had appointed a group operating officer without the right qualifications at a spectacular salary, making technical people report to him. And all this was either flying under the radar, or the regulator and this powerful NSE board was keeping its eyes tightly shut. That is what we have called regulatory capture in our book Absolute Power that we published about the co-location scandal. Now, had NSE been subject to the RTI Act, it might have found it far harder to hide all this. Because why was it able to do it? Why was it able to have this regulator in its kabza or capture? Is because of its market dominance, its immense profitability, and its advertising clout, which silenced the media because it was a huge advertiser. So it escaped scrutiny from anybody, and it silenced critical questions, and it was nasty with those of us who dared to question it. The situation in that manner is the same. Overall turnover may be slightly less, but NSE still has 90% of the cash equity market, 80% of the derivatives market. It has got enormous pricing power and fee income, so it's extraordinarily profitable. Now, earlier this month, as I said, the RTI judgment could throw a little more sunlight on what the exchange does. But the argument here would be, hello, we are making an IPO, and that will bring about its own mandatory disclosures under the listing agreement, and there is going to be transparency. And then again, we are a private listed company. Paradoxically, all that is true, but in fact, there will be more compulsions because once you're a listed entity, it will alter management incentives and subject an already profitable exchange. Remember, they're hugely profitable, and the profit comes from fees that are collected from intermediaries, from us, the investors. And it can be more and more profitable and help the small group of investors only if it collects more. So there is going to be relentless pressure to deliver revenue and profit growth quarter on quarter, and that can only come from higher turnover, which means froth. So when a public utility faces intense pressure to do this and maximize short term shareholder value, there is a temptation to cut corners, encourage frothy trading volumes, skirt compliance, and supervisory obligations as a first level regulator. I'm not talking through my hat, it has happened already. Even when it was not listed, NSE's reluctance and failure to regulate broker members and encourage and give certificates for them whipping up large trading volumes without doing the necessary investigation as a first line regulator. But whose money were they using? Were they misusing client funds? This led to 32 broker defaults between May 2019 and early 2022. We were probably the only magazine which kept writing about it, In each of these defaults, investors have lost hundreds of crores. The biggest of them was Carvey, and you know how many of you have lost money over there and not got it back. That money has never come back. The regulator just shrugs. So, this tension between profit maximization and public obligations of exchanges is a globally recognized concern, and it's real, and it has happened even when the NSE was a private body, which makes it all the more important that the RTI Act should apply to the exchange's regulatory functions. Now, let's look at the IPO and listing. Calling it a IPO, but it's really filed a draft red herring prospectus to list its shares through an offer for sale. This clearance has come after 10 years. 2015 is when it wanted to go public. That's when the Colo scam happened. All the investigations started. Now they have either been abandoned or settled. And NSE has paid a lot of money to settle them. So before its clearance for the issue and listing, it agreed to pay 1,491 crore to settle the Colo and dark fiber cases. Earlier, it had paid 643 crores for TAP architecture case, 72 crores for a massive technical glitch that had happened in 2021, which was also being investigated. There were cases which NSE had won. The Supreme Court had asked SEBI to return some money. All that has been quietly buried and settled, and many cases that were ongoing, including leak of data to a couple of professors, all that has been forgotten and abandoned. Everyone wants it like that. SEBI doesn't want it to continue. So who wants NSE to be clean and transparent? Obviously, we the investors, we the people in the system, and that can only happen if it is subject to RTI. SEBI can settle this with a binding administrative directive to all exchanges to comply with the RTI Act, appoint public information officers, put in place systems for receiving and answering public queries, not only for the NSE but for all exchanges. This will end the long legal standoff, and it'll finish everything because all the arguments against applicability of the RTI Act based on commercial confidentiality, the fact that SEBI's oversight is sufficient, all that has been comprehensively dismantled and finished. So SEBI has the legal authority to put an end to it, but like I said, it has done nothing, even though its official stance in 2010 was that NSE ought to be under RTI. What remains on trial is whether SEBI, even today, has the ability to exert itself, act as a regulator, and act in favor of transparency and accountability. In fact, let's look at this issue back in 2010 when the CIC judgment went against the NSE. The late Prakash Kardale, an RTI activist, had asked a very, very pertinent question, and I'm quoting this. What is wrong with being transparent unless one desperately wants to cover up one's own misdeeds? Transparency in public life, either as the spirit or as a piece of legislation, when codified into law, knows its legitimate Lakshman Rekha. It does not cause unwarranted invasion of an individual's privacy. It does not expect disclosure of any information that would be detrimental to society at large. On the other hand, it attacks excessive and unnecessary secrecy that, in fact, is injurious to the well being of society. Any opposition to the spirit of transparency, therefore, must be seen as a profound disrespect to society. Subsequent events over the last 16 years have shown how prescient this was, but neither NSE nor SEBI, a captured SEBI, was in a listening mode. So, after the Delhi High Court has removed yet another legal challenge to bring NSE within the RTI framework, SEBI has no credible reason to remain passive. It is hopefully in charge and can issue clear directions recognizing every recognized exchange to appoint PIOs and get on with it and be subject to the RTI Act. Whether SEBI does it remains to be seen, and we are all watching. You need to watch too because it affects you. If you agree with what I said, share this, let's make a noise, and do subscribe.